14A, just report from County of Washington, State of Michigan, is now in session. All those having business before the court draw near, and the Honorable Judge J. Simpson preside.
Court does call the case of the People versus Mohammed Day.
Ashley Feltus with the People.
And Assistant Public Defender Natalie Pate. Mr. Deanne, please keep yourself quiet in the courtroom.
You're fired. Conflict of interest. I'm a blood too. Can I get the fuck out of here now? She's fired. I would like to schedule for get the fuck off my case. You're fired. You're fired. I'm not playing to shit. You're fired. With the ugly ass, dusty ass suit. I'll represent myself. We can schedule for trial. When's your trial docket, please?
Well,
conflict of interest. She's ugly and she got a dirty ass suit on.
Hang on.
Get the fuck off my case. Where your wig at? Where's your wig at? Where's your fucking wig at? Suck my dick. Let's go. Let's go, bitch. I'm out of here. Can you suck my dick right now? I only feel like I'm suck my dick or warrior dick.
Yes, Mr. Dan.
Mr.
Dan.
Big red.
Take him out.
Spread your booty cheek so me and my nigga put my dick in. That's why you got two cheeks, bitch. Bitch. Why you wonder why they call you bitch? I bet you. You got two booty cheeks, one for me and one for my nigga.
I apologize to the court.
Why? Did you have anything to do with that?
No, but I still apologize to the court.
No, you don't. Yeah.
I intend to reauthorize this felony as stated on the statement.
Yeah, so it's coming back to me.
Yes.
Thank you for the apology, Ms. Pate, but you really didn't need to apologize. I knew what I was going to be starting my date with.
Yep. Okay. Go! Will you hand me my screen box? Now go. Freak.
In Arbor Woods versus Kiera Morris. This is her motion to set aside default.
It is indeed. And we did file
I'm here, Judge. I'm sorry. I couldn't get my phone to work.
All right. That's her. Oh, there you are. Hello. State your name.
Kiera Morris.
All right. This is your request to set aside the default?
Yes, sir.
All right. And what's the basis? You said you were unaware of the hearing?
No, so I was aware of the hearing. I was available for the first hearing. The attorney's office reached out to me and let me know that the staff needed to be trained and that they were looking to resolve. So I had to keep reaching out, and nobody reached out to try to come to a resolve. So when the court date did come up, I just couldn't get back in time because I am working a contract with veterans in Las Vegas right now. So that is the reason why that I could not make it. I do believe my Zoom hearing was denied. So that's why I need to file a motion to actually be here.
Okay. Have the funds been paid to the landlord?
So that was the situation for the court date. Just in agreement of what funds they're saying are owed is not accurate.
Okay. I took a judgment was taken in November for $1,571.06. You're saying you don't owe that amount?
Yes, sir. That judgment was the day that I was not there. So we were supposed to try to come to a resolve. The issue actually stemmed from May. And Rachel Dornbush, I did speak with her on the issue in May. She did try to correct some things that we did not come to an agreement. There was a court date scheduled for May 16th, but somehow that was dismissed. But even on the Arbor Woods paperwork, they still had down that I had a balance. So we still should have been in court. So that is, I guess they didn't communicate that with their attorney because this is like all the way from May. So this issue has never been taken care
of. Your Honor,
Yes.
I'm looking at the ledger, and the reason that the case was dismissed is because there was a balance. I mean, there was a credit. I mean, there was nothing due and owing. So the case was dismissed for that reason. Your Honor, first and foremost, I mean, I'm going to object to the motion even proceeding because none of that was stated in the motion. The motion says I was unaware of the hearing. If there was something more that needed to be addressed as a part of this motion, Ms. Moore should have included that in the motion instead of making a false statement alleging that she was unaware of the hearing. That is verbatim what her motion says. I was unaware of the hearing, and this was only filed beyond 10 days because of the holiday. Well, if she was aware of the hearing, then she could have filed her motion on November 19th, November 20th. She could have filed it long before the holiday occurred, which prevented her allegedly from getting to the court to do it. So I'm going to object, Your Honor, that this motion hearing even moves forward on that basis. And I am going to request actual attorney's fees because the motion that was filed is clearly erroneous and a false statement was made to the court.
I actually did file more than one motion. The motion that I did file for the Zoom hearing, it was actually denied. So I did have to file another motion. And I did speak with two representatives at the court. One of the girls' name was Ashley, and they did let me know that I did have that time I actually sent a paper and I took a scan of it, and I sent that in with the explanation of what was going on with the case. So I think you may have read it incorrectly. I can pull it up and I can read it to you now. But the only reason why I was not there is because we were supposed to come to a resolve and no one ever reached out. And Rachel Dornbush, when you're speaking on it was a zero balance, if you check back onto your attorney's documents, onto your client's documents on the ledger, the same day that I spoke with you and you put that credit onto my account and we did not agree on my rental rate, they went back and put a non-sufficient funds fee there. So on the same day, there was definitely a balance and we should have been in court on the 16th. They didn't communicate that with you. My rent was supposed to go up in August. I'm sorry.
There was, and I'm just to try to get the order of this, and I don't know if you've got this, Ms. Dornbush, so what I have is exactly what you stated on the motion. On her request for a Zoom hearing, she just had indicated that she's currently working out of the state of Las Vegas. I was hoping to come and resolve, but I have not received a call back yet. I can get a flight after work, but I'd be late for court. Please allow me to appear via Zoom. There's a 3-hour time difference.
And so I believe that was in the Zoom request, Your Honor, that was submitted to the court the day before the hearing on, I think, November 17th at around 3:30 p.m., which was after she contacted our office on the same day. She contacted our office around 3 p.m. and was reminded of the in-person bench trial scheduled for the 18th. But her motion that was filed with the court says, I was unaware of the hearing and it's only after 10 days because of the holiday. That is false. Ms. Moore was 100% aware of the hearing.
If we're speaking on things, I'm sorry, my phone blanked out. If that may have been, I did file 2 motions. So I don't know if both of them actually came through. I can pull up the ones that I have and I can send it back into the court.
Ma'am, so I have your signature on a motion to set aside the default. And under paragraph 2, you're asking the court to set aside the judgment. And it indicates that it must be filed within 10 days of the default judgment. And then it's because, and you wrote in, I was unaware of the hearing, and it's only after 10 days because of the holiday. The first part of that is it's patently false. You were aware of the hearing because you filed the request for a Zoom on that, so you knew the hearing was taking place. And then you said it's after 10 days because of the holiday. I don't even get that because the judgment was on November 18th, and there's at least really 7 days, well, more than 7 days before the holiday. There was like 9 days before the holiday that you could have filed it. So,
I'm confused on the motion.
It did not get filed with us until December 1st was your signature, and that's when our timestamp is.
And yes, I
So-
do. I'm not trying to cut you off. I did call in. She did let me know that I had a few more days, and she let me know that I had to file a motion. I have the emails from you guys, and I never got the $20, I guess the check thing to actually put the motion in online. So I had to have someone come up there and do it. I would have had the motion in prior to that. My Zoom hearing was denied, and I did submit a piece of paper with a lengthy information on what we're talking about. This is the same conversation that we had prior to when the other attorney decided that they needed to train staff and we're trying to come to a resolve. So my information hasn't changed. And my issue hasn't changed either. And if we would have been in court in May, because that ledger says that I
in
had a
May,
balance.
ma'am, trying to go back to May, Ms. Dornbush just stated you had a credit on your account and that's why they dismissed it.
Correct, the same
So-
day, Judge. Ms. Dornbush is not
But-
acknowledging that her client put a non-sufficient funds fee and reversed that payment back onto my ledger after I spoke with her.
When are you saying that happened?
That happened on the same day on 5/6 of 2025.
Do you see that on the account, Ms. Dornbush?
I do see that, Your Honor, and I believe, but I can't speak to it with certainty because I was unaware of that until Ms. Morris brought that up. But if a dismissal had already been submitted to the court, my client would have then had to motion the court to reinstate the case, number one, to try to pursue those amounts. And following that, Ms. Morris did continue to make payments on the account in June. Payments were made and credits were done to the account, leaving a balance of $50.49. And so I don't believe my client felt there was a reason to reinstate based on subsequent payments being made.
Well, sorry, I don't want to cut you off. Just to let you know, Ms. Dornbush, because I know you didn't speak to your client. I spoke to them and we were going back and forth. They ignored my phone calls, a whole lot of things. That was done probably about 2 hours after me and you had spoke. And they literally have it on the ledger. They knew about it and it took over 30 days for them to actually correct that. And they also put a $30 late fee onto May's rent as well. So this is an issue that needed to be addressed because just like with the $2, my rent was supposed to go up in August. That's a whole 12 months. So I understand
what is her current balance?
The current balance, Your Honor, hold on. I've got to find the current ledger that I have for this case. Give me just one moment. With December, Your Honor, $2,364.19.
And ma'am, if I take everything that you're saying, how much are you saying you owe?
Honestly, Judge, there was a discrepancy in
I know
September.
that.
Okay,
So
I'm saying in
you tell
September.
me,
Yeah.
taking out all of that, how much do you think you owe right now?
I think I owe them around $300 from the discrepancy that the office made in September, sending out a notice, 7-day notice, saying that my rent was $360.
Did you pay December rent?
Yes, I did. I paid it into escrow at the court, and I did that with November's rent as well.
I've got 700. So you're saying that if I take that 700 off, add the 300, so basically $1,000, that you're saying that there's an error on your account in the amount of $1,364.19.
Yes, it is.
Absolutely not, Your
You
Honor.
can say absolutely not.
Where
if you
is
look
that
at the
going to
first.
come from, ma'am?
So where it's coming from is my lease is supposed to start in August. They charged me a lease increase in May, June, and July. My lease is supposed to be from 8/1/2024 to.
All right. So in May, June, and July, what are you saying they charged?
They charged me $694 for lot rent.
And if you're saying that, what should it have been?
My lot rent should have been $657.
So that's about a $50 difference each of those months. That's $150.
On top of late fees.
So how many late fees?
They charge you 2 late fees per month.
Okay, so
that's
even if they
$85
did
per
that,
month.
And Ms. Dornbush, maximum amount of late fees per month is what?
Your Honor, the late fees total per month is 55 that gets charged on after the 5th and $30 that gets charged on the 21st. So it's $85 a month. However, let me go look at Miss Morris's ledger and see if she's actually making these payments timely. Because if she's not making her payments timely, whether there's a discrepancy or not, the late fee would have hit.
Okay,
So
I hear you on that. But what I'm getting at is your numbers aren't matching, because even if I take 85, give me 85 times 3, give me 85 times 4.
5 times 4, 340.
340. So I've got 150 and 340. Where else are you claiming that there's a discrepancy of some type?
Okay, so moving forward, if you look at July, well, you took that. If you said my rent was $657 in July, I went into the office. They locked my mailbox, and I have been kicked out of the customer portal to pay online. So I get charged a $10 fee with every payment.
Ma'am, listen to me.
If you look on my
listen
ledger,
to me. You are claiming that there is some $1,300, almost $1,400. That is a discrepancy on your account. I'm
Yes,
asking
sir.
you for where that discrepancy is.
okay,
You
sir,
are
and
giving me 150. I'm not
Sir.
agreeing with you. I'm just saying,
Mhm.
where are you getting these numbers?
So where I'm getting these numbers from are my ledger. It started in May. So they put a non-sufficient funds fee on the account. After they put that non-sufficient funds fee, they added that money that was owed for May, the rent, they added that onto June. I have a 7-day notice from June. It says my rent at the top of the paper is $657, but they're not putting that onto the ledger. So that is incurring a balance. They put the non-sufficient funds fee, put the 718 back onto my ledger around June 12th or June 13th. Moving forward, we still had a balance in July. No one is trying to come to an agreement about the balance with my ledger. So it kept on incurring. Then we get to August. I go into the office. They say I owe $175. So she says, well, you know what? Since you've been locked out of your account, her name is Dana. She said, you've been locked out of your account. We'll credit you those $10 fees back. I'll do 17 of them. We're going to investigate. We'll do more. Kenya just took those $170 credits off in October. Those were supposed to be taken off in August. I paid my October rent to the office. They told the court that they didn't have any rent. If you look at 9/6 on my 7-day notice, Kenya, the new manager, sent out a letter saying I owe $360.
Ma'am, you are telling me that there's some $1,300, $1,400. You are not telling me where those numbers are coming from. You
Okay,
have
so let me
given
rephrase
me
this,
a
Judge.
total amount
Mhm.
of $490, basically, that you're saying shouldn't be on your account.
I said there's a total, the $450, if you look at my ledger that I paid in September, that was supposed to be the total balance owing for September. That was a staff error. It was $360. I made a $450 payment to cover the late fees. So I should not have a balance. That was a staff error, not my fault. They sent me one paper in the mail and they sent another paper to the court. They also tried to steal my money order. I also submitted to the court the payments that are made on their check system. My money order from May is not in that check system. Kenya, the manager, asked me, well, did they actually put it back into the check system? I said, I don't know. So I asked her, could I have proof? So all of this, my account is screwed up since May because of these different charges. They're saying I owe $2,000, but they also charged me a late fee and my rent was in escrow. In November, my rent was paid to the office. The only time my rent was short was in September of 2025. And that was a staff office error. That was not a tenant error. I paid what they said was owed. Then they turn around the same day and send the court the same paper with different numbers on it. That's not my fault. All of their information that they even sent into the court with my lot rent. Sometimes it's $266, sometimes it's $391. And Rachel Dornbush, you or the rest of your colleagues never addresses it. They started my lease last year in 2024 in July. It was
All right,
supposed to start in August.
ma'am, here's the problem. Problem is, your motion says none of this.
Is that my motion, a motion that I did, or did someone else do that?
I don't know.
Because I can
It's the
send it back
motion
in.
you-
I can send proof back in.
Ma'am, you know, if you keep interrupting me, because I'm about done. You're not answering my question. You're not giving me the figures. You gave me some figures which amount to 490, but that doesn't even make any sense to me.
Okay. My question is,
And-
how does it not make sense for me, but it makes sense from the attorney? You're
I'm
being
done.
biased.
I'm done. You're not
You're
gonna
biased.
interrupt me.
You're very biased.
You're not gonna keep interrupting me. Motion
Sorry, I
denied.
was never trying to interrupt you.
Motion
You're very
denied, writ
biased.
may issue. Thank
You're
you.
very
I'm done.
biased and disrespectful.
I'm done.
That doesn't matter. You're disrespectful and
am
you're very
done.
biased. You need to do your
I
job. You don't
am
know how to do your
done.
job. That's
Mute
all.
her. I am done. Motion denied.
Your Honor, I would request that the money's held in escrow. I think, Your Honor.
The monies held in escrow are released to plaintiff and will be applied to the account balance.
Thank you, Your Honor.
You have an attorney. You have a boss as well. You're
Code-
very biased, rude,
Code
and
just-
disrespectful.
Mute her and kick her out of the meeting.
Sidvin Realty LLC versus Mayan Chardon.
Brad Lammy here for the plaintiff, judge, or for Sidman.
Yes, and Ms. Chardon is present and coming forth. I know that this case is on appeal. So I'm not sure, and I don't have an actual motion before the court except for plaintiff's motion for warrant of possession. Is that correct?
Yes, Judge, and I have not filed a response to the appeal, but this was a standard agreement, and so realistically, the appeal should be barred and the writ should be entered.
Okay. Before I allow her to address, so we can't bar people from filing an appeal.
I understand, Judge.
Just so Ms. Chardon understands why we can't bar people from filing an appeal. The likelihood that you'll win on appeal, if it's fully explained to you that you're waiving your right to assert defenses, your right to trial, and your right to appeal, and the judge reviews that, then the likelihood of you being victorious on appeal would be very questionable. But again, the appellate judge will review the record for that decision. So that remains. The issue is, just because you appeal does not stay the writ of possession if you have not fully paid your rent into court.
I do understand.
All right, and have you been able to do so?
To
Pay your rent fully into court?
So I believe that you're the judge that signed off on my
Your
papers.
informer paupers does not keep you from paying your rent into court.
Do understand that, but I do have a motion with the folder.
You don't have your motion.
I'm not sure why, but it was joined in with my.
Oh, it went to circuit court. But so your motion is to stay. What is your motion?
I have a couple of motions.
Well, that's going to be with circuit court.
But there should be a motion with you.
It should not be. Once it's appealed, I do not have jurisdiction. The only jurisdiction I retain is for the writ of possession.
So
Or
I
this
have
court.
a temporary stay for writ of possession that I filed with the district.
Yeah,
And it
that actually
be
should
with you
have
guys.
stayed with us.
But I also have a stamped copy that I did. And then also a waiver to supersede his bond. And
I'll see what you have, because it probably still went to circuit court.
I have if you can make a copy, because that was supposed to be on Brad Lammy's. I have not been able to.
Yeah, see this other one, these, I honestly do think these should be before me. The other one's an emergency motion for additional time to vacate due to extreme hardship, because that's not gonna,
And
you're not going to be able to, like, these will not uphold here today. You took a standard agreement. You've waived your right to assert defenses. Technically, and then these are additional defenses. You had a full hearing, actually did hear it. I was sitting next door and I heard it on Zoom. So I wasn't the judge who was over your hearing. That was my partner, Judge Langford. I know I signed the informer papyrus, which means you don't have to file your filing fees for your appeal.
But does that not?
That does not include, that does not keep you from having to pay your rent into the court, circuit court clerk.
But with me and the paupers, did that not confirm indigeneity?
That will not save you from a writ of possession.
And
But it's actually very
but I
clear.
cannot pay my superseded bond. And that's why I gave you guys the informed paupers.
So, and you're in it, the informer paupers keeps you from paying your filing fees and what is necessary for you to file for your appeal, which is separate and distinct from your requirement to pay your rent as it becomes due into the circuit court clerk. Those are separate and distinct.
I have no intention to not pay the rent while it is in appeals, but at the same time, we do have a hospitable or hospital, like the property is hospitable.
More important for you to move.
And he also,
And that's what
I understand you guys want me to just move in 7 days, but the reason why I got this apartment was he got my first month's rent and deposit from Salvation Army.
I'm not gonna let you relitigate this matter. It was heard and adjudicated before Judge Langford.
And it was.
And I'm not gonna reconsider your arguments at this time, and that a standard agreement was reached and agreed upon. I will not sit here and rehear what you stated before my partner, Judge Langford. That would be improper, and it is not to be considered at this time. The only argument I can tell you is that before me is you want me to stay the writ of possession during appeal. And Mr. Lammy, you are objecting to that, correct?
Correct, Judge. And I mean, I'll briefly cite for the court, but the notion that she's citing in form of paupery, the Kentucky Court of Appeals and Supreme Court have previously ruled that an appeal cannot be denied on the basis of not paying rent into court where it's summarily dismissed, but that the equitable balance is that the rent must be paid into court in order to stay a writ of possession. If there's no rent, there's no stay. So the basis of the writ is she did not pay back rent into court or current rent as the matter was proceeding forward, and thus there is no stay that is proper for the writ. And I believe that I think that's the Fickey case.
Yes, it is. Which has been argued before in this court.
Respectfully, that rule does not apply to this case. It's being appealed on the grounds of habitability. I can't say the word. Habitability violations and manufactured non-payment. The Kentucky law, specifically KRS 383595 and 383640, a landlord cannot demand full rent while failing to provide essential services such as heat.
That would have been your arguments to have been made during your eviction hearing. And then if you did not read, and then you did not win, it was litigated, it was heard, and a judgment. So was it a standard agreement or was a judgment entered?
I also was.
Hold on a moment, Mr. Lammy, was the judgment entered or was a standard agreement reached? A standard agreement, correct?
Judge, yeah, essentially what happened is Langford indicated that she was going to rule in the plaintiff's favor and asked us if we would offer the standard agreement and if the defendant was willing to take that. So this is actually a standard agreement that is up on appeal and not the merits.
And so oftentimes, which is a courtesy that this court does try to do to try to save an eviction judgment from being placed on a tenant's record based on the way the hearing is going at the time, that if it's renegotiated during the hearing and an offer and acceptance is made. So my understanding, again, was that you accepted a standard agreement. Was it to vacate, Mr. Lammy? Because again, I don't have the file. Was to vacate. It was a standard agreement to vacate that was offered to you and you accepted it. And then since then you have you did not vacate, and you did file an appeal, but any misperception by you, Ms. Chardon, that that's going to keep you from having to pay into the court is just that,
I
a
don't have any-
misperception.
I don't have a misperception about.
Okay, so your
not paying
motion
to
is
the
denied.
court, but I intend to pay to the court, ma'am,
You
but
sh-
I have an autistic son. I can't just leave in 7 days. Plus, you guys gave me that time during Thanksgiving. I'm not entirely
Ma'am,
sure what
you're-
I'm supposed to
you're-
find.
You unfortunately,
And I
are
also
one-
told the judge at that time that I have an autistic son, and the judge
I know
is,
plenty of people who have autistic sons and autistic daughters. What exactly are you implying when you say
I'm
you
not
have an
saying-
autistic child?
I'm not saying that I'm implying anything.
Then why are
It's-
you bringing it up?
We're being put on the street when I have a child that has special needs.
Okay,
I have therapist appointments and things that I'm
Many
trying to
people
get
do.
done.
many people do.
I do understand that, but my case is different, ma'am, because I gave this man first month's deposit and paid him for months in a home that has been
Again,
unfinished.
you're
I even
trying
have a
to
video of
relitigate.
this
I'm
man.
stopping you again. You're trying to relitigate what you already got to
I
litigate in
just
front of
need
a
more
judge.
time
You
in
will
this
not get more
home,
time.
ma'am,
I'm so sorry. And
while
you-
I'm in appeals
No,
with a special
then pay
needs
into the
child.
court. If you pay into the
Pay
court,
them the $1,000.
if
or
you pay
guys
everything in the
waive?
court before they decide to execute on the warrant for possession, maybe they'll try to reconsider.
Who's
but,
they? You or them?
Mr. Lammy, no, it's not, because they're entitled to their
But what
warrant for
about my
possession today.
appeal, though?
It will continue.
So me having an appeal continues, but I
Not,
get put out of the home?
Yes.
How is that legal?
I
And
have-
how is that?
I'm telling you, you're not
how
the
is
first
that
person who has
standard
been
under
concerned
Kentucky
and who,
law,
you're not
under
the first, let me
Kentucky
finish.
Ulta law?
We're not gonna argue.
I'm
Let
not
me
arguing.
finish. You're not the first person who has been put in this predicament. But the law is also meant to be equitable to both sides. And one of the things about appeal is like, okay, I'm saying that I'm willing to pay into the court as I fight on my appeal. Hence, I'm willing to pay for where I am, and I'm willing to still win that in the end. Because if you were victorious, listen, if you were victorious, all that money that's been put into the circuit court clerk could potentially, that money or a portion of it, be returned to you because you are victorious. But at the same time, if the landlord is victorious, then that money would go to him, to that entity, because they are not out either while they've been housing you. That is what I'm trying to explain to you, Ms. Chardon. So you have, and I think I've heard your full argument, as far as the writ of possession, which is the only thing before this court, because I'm not reconsidering the rest of your motions. That would give you an opportunity to relitigate when you took a standard agreement and you waived your right to defenses, your right to trial, and your right to appeal. So again, we don't bar you from filing an appeal. You can still feel free to do so, but you'll still need to follow all the rules of an appeal, which includes paying your full rent into the circuit court as it becomes due. I wish you the best. Again, I don't know if you've tried to talk to community involved individuals, other partners, but it would be in your best interest to continue to move out, as I know you've had time since this hearing as well to try to do so. That's all for today. Your motions are denied.
Your excuse.
Judge Brad Lammy for the plaintiff, is the writ going to be entered just as a clarifying point?
The court will sign the writ for possession. It will be entered today.
Okay.
All right,
thank
so
you.
I want you to also understand, Ms. Chardon, with them, Ms.
So
Chardon,
under-
listen.
I cannot be required to pay full rent during litigation when essential services has failed. I haven't had
Denied.
HVAC
Denied.
since I started living here, ma'am.
Motion
I had
is
no
denied.
AC. I pointed that out.
Motion is denied. The motion is denied.
That's crazy.
Why you want to continue to live somewhere uninhabitable, I do not know either.
I have no money. I don't have a way to leave. I don't have first
this
month's
other
deposit.
issue,
He took charitable organizations.
denied, then go back to those charitable organizations best you can. Your motions are denied. And again, I'm executing a writ for possession, which means they have the authority to use that writ for possession to contact the sheriff's office and remove you. And they will do that.
Even if it's in appeals.
Yes. I don't know how, yes, ma'am.
So I guess,
So
do I go
please.
to talk to the circuit court then?
They're not, You can make any motions on circuit court, but the jurisdiction for the writ of possession remains here.
I understand that, so.
So they won't overturn that. Unless I'm wrong on the law, which.
So if I win my appeal, what happens with this writ of possession?
They won't wait for that. The writ of possession is going through today. Okay.
So just to clarify, the reason why you won't listen to or stay a writ of possession is because the previous judge said that my motions, anything that I said, regardless of how this lot was presented, because of what she decided, it's improper for you to make any other further decisions or even stay the writ for this property, because
You're convoluting two different things.
not really.
Yes, really.
That's really what you said.
Yes, really. No, I'm not. You're combining two different things.
You're not.
You're in the
staying
middle of a
writ
hearing.
because
I'm gonna say this one last
previous
time just for you.
judge-
You're in the middle of a hearing. The understanding, and again, I recall this as I was next door when you were sitting there watching on Zoom. The way the hearing was going was not going to be favorable to you. Okay? The testimony and the same things you're kind of saying today. Let's stop. Do not interrupt me.
I'm just reading.
You were the same way in the hearing. Stop interrupting. Okay. So how it was going, the hearing was not fully concluded. Instead, an offer was made to you, a settlement offer, which was the standard agreement. You decided to take the standard agreement. Correct?
No.
Okay, then you'll go to the record. That's
It
all
wasn't
for
that
today.
I
The motion,
decided-
your
it
motions
wasn't
before
that
the
I
court are
decided. The
denied.
judge sat here and said, we have other cases to go, and if you
Ma'am,
don't
if
decide.
you feel that, and again, if you went on appeal, you went on appeal, but it will not stop the motion, the writ for possession from moving forward. Good luck to you. I wish you the best, Ms. Chardon.
I hope all those people that have autistic kids.
Ma'am, don't you use, this other thing, I hope you quit
don't have
using your
any
autistic son as a
issues.
pawn. Because there
not
are plenty
using
of
my
people,
autistic son
then
as a
don't do that.
ma'am.
Because I know plenty of people are
But you
autistic
do.
in my family and the
I
ones
hope
next
you
door
have
to
a
me. And
blessed
right
day.
now,
I
you need
hope
to
your
stop that.
Christmas
You need to stop that.
No, I will not, because you did that. Have a great day, though. And I'll get my next one.
Please leave before you have some other issues.
Ma'am.
All right, and just for the record, there were two motions before the court that I did add. Again, I note that they probably are with this, the clerk, file stamp copies are probably with the case on appeal. The other one is, additional time to vacate due to extreme hardship is also, is also being denied. And then plaintiff's motion for warrant possession is granted.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. Today is absolutely. We need an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Green, we're gonna start bringing people in for. People gonna learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it? Okay.
Come and go, no patience. Trust me, today, I'm sitting up here, I'm the one that needs a drink.